Hey guys, welcome to my channel. So I'm going to play you guys Ethan Crumbley's court hearing that was actually yesterday. I'm sorry I'm a little late getting it uploaded. I wish I would have been able to get it out yesterday, but I was working on another video. A lot of you guys probably already seen it, but there's probably still some of you guys that haven't seen it yet. But first I've been wanting to upload this video of Ethan falling in the restaurant. It's been out for a while too. I just haven't got around to uploading it. So I figured I'd just combine it and upload it with this video. For those of you who haven't seen it, it's pretty interesting. He's in the restaurant where he works, where he's working temporarily. It sounds like he just kind of filled in for people when they couldn't make it. So he walks into the kitchen and he's all wobbly looking, like he could barely walk, and he falls and it looks like he probably hit his head, and then he tries to get up and it's like he's gonna fall again. And somebody comes running over and helps him and asks him, if he's all right, and you could hear him kind of say that he's not feeling very good. So it just makes you wonder. Originally, when I heard about this before I seen it, I was like, okay, so what if he hit his head so hard that it did some damage and it caused something? Because so weird. The day that I did the first live on this case, my aunt was over and she was talking about how that these schools have been seeing a lot recently of kids getting head injuries and getting concussions, whether it be from falling from sports or just falling. And it's creating like a lot of depression in kids. It's basically changing them. Like before the concussion, they were a totally different person. And then after, they're like, whether they're having different kind of issues like behavior issues or depression and stuff like that. So of course, I mean, it makes sense, but the fact that she brought it up that day and then we're talking about this case, right? And I was actually going to bring it up when California Thunder was up on panel with me that night. Do you guys remember that? And I was asking them, what do you think changed? Like, what caused this? And I meant to bring that up, what my aunt was saying, and just to throw it out there, like, what if he fell and hit his head and had a concussion? And that just kind of changed everything. Because we were talking about how in his old vlogs, when he was younger, well, he still is young, but in his old vlogs, he just seemed so innocent and like a normal young kid. So it was like, what happened? So I forgot to bring it up, but then I don't know if it was later that night or the next day or a couple days after, I got an email saying, "Hey, Tiff, did you see that video where Ethan falls and hits his head pretty bad at the restaurant?" And I'm like, "No, I haven't seen it." And I'm like, "Oh my God." I thought that's so weird because I was going to bring that up. Like, what if he had a head injury? Like, what if he fell and hit his head? And it was just so weird. But now, after watching it, I believe that the fall wasn't the cause. That was just a symptom of something going on with him. I mean, there was something. Was he maybe on drugs, high? Was he? But I guess it could still be the cause, because let's say he just was high or was on some kind of medication, or somebody gave him some kind of pills or drugs, or he took something. I mean, maybe he found something of his parents. Maybe they gave him something, was dizzy for some reason, and then falls and then hits his head, creating some kind of injury and some kind of something going on in his head, and that caused it. But I'm not sure. But now from watching it, I don't know. I'm wondering if something was already going on in his head before and the fall was just a symptom, or if whatever was going on to make him fall has nothing to do with him turning kind of crazy, killing everybody, or did it have something to do with it? Like a symptom of a bigger problem, or did it cause a bigger problem? Does that make sense? Because I didn't expect that when I watched it. When I got the emails of him falling and people talking about the video of him falling, I didn't expect him to be all wobbly, and I just thought it was going to be like a bad fall. But no, it was something was making him wobbly. I don't know. What do you guys think? Do you guys think it was like he was high on something? Or is it whatever is going on in his head that caused him to shoot everybody is the same issue that is causing him to fall? I know it's two different things, but I'm saying, like, is there some underlying issue that's at play here? I don't know. I'm just trying to figure that out. That's weird, because I guess the restaurant, they called his parents after that, and I guess his mom just said it's probably just because he didn't eat all day. But the restaurant owner was like, no, it didn't seem like the way somebody would act if they didn't eat all day, is what the restaurant owner said in the article. They must have interviewed her, and that's what she was saying, like, well, no, it doesn't seem like that's the answer or that's what was going on. She thought it was something else. Maybe there's some kind of underlying issue. And I guess she said that Eli, his brother, used to work there. And they had a issue with him. I guess one day the back room smelled like marijuana and they asked him and they said, well, we're going to call your parents. And he said, well, who do you think gave it to me? I guess he made it seem like that his dad is the one that gave him the weed. All right, so let me play that real quick and then let's watch the court hearing.
Oh, you all right? Yeah, here. You all right? Yeah. All right, fine. Oh, you all right? Yeah, here. You all right? Yeah. All right, fine. You all right? Here. You all right? Yeah. All right.
Yeah, it should be okay, just because I guess they want to discuss anything.
Yeah, if anybody wants to, I'll give you my cell phone.
Yeah, I was gonna say give your phone.
No, sure, absolutely.
Yeah, for now it'll be fine if you zoom in your phone.
Good Zoom on it.
Okay, there.
So-
So if push comes to shove, we
Yeah,
can do
that
that.
says,
This step out, but if not, then you can just do it right here.
and if
just-
anybody wants to just talk to me on the cell phone, I'll go out. If anybody wants me to zoom in or zoom in, you just have to give me your card.
Yeah, and-
What do you call it? That's good.
Oh, yeah, there is no passcode, and our Zoom is, do you want to compare?
Yeah. Yeah, we always do.
Yeah, I want to compare.
Yeah, Kanika felt bad. I told her, you go home.
Yeah, no,
Pick up
no.
your child and go home. I'll do
She
it.
had other things on her mind, yeah, now I hear the situation.
But you know, I mean, would you want me to?
Stay here for now. If we have something to discuss, then if I step out, it's probably just gonna be waivers, sets, or adjourns for discovery.
Exactly. And then the trial. Oh, really?
I just don't notice that. Yeah, no, that's it. I know you're
Okay.
Yeah. I'm very aware.
Yes.
Good afternoon.
Afternoon. Afternoon.
Hey, Deb. Hey, Amy.
Hello. Hey, Mark. Hey, Amy, I haven't talked to you. Hello.
What?
Can you guys hear me okay?
Yeah. Kelly, you figured it out.
I did figure it out. Thank God my son is still home from college.
Kelly?
Hi.
When did that happen?
I know. Oh, well, during COVID, you know.
afternoon. Please be seated. Do we have the jail up too?
Control on V2.
Can you block me down so a little bit further? Or switch everybody around so I can see the defendant better.
If the judge asks you to take your mask off during the court proceeding, you take it off.
Okay, here we go. Everybody's in? Okay. You need to unmute me. Okay. It looks like I'm still muted. Julie. Okay. Calling the case of People versus Ethan Crumbley, 2-1-6611. Your appearances, please. Mr. Keese?
Thank you, Mark Keese. Thank you, Judge. Mark Keese on behalf of People.
Thank you, Ms. Collins.
And Your Honor, good afternoon, Your Honor. Assistant Prosecutor Kelly Collins appearing on behalf of the people as well.
And Ms. Lofton.
Yes, good afternoon, Your Honor. Paulette Michelle Lofton on behalf of Mr. Crumbley. Your Honor, we also have Amy Hopp, who has been appointed second chair. And we also have Deborah McKelvey, who has been appointed to act as Mr. Crumbley's guardian ad litem.
Thank you. With that, Ms. Hopp, if you just want to state your full name, and then we'll give Ms. McKelvey a chance to do that as well.
Amy Hopp appearing on behalf of Ethan Crumbley.
Thank you. And Ms. McKelvey.
Good afternoon, Your Honor. Deborah H. McKelvey, court-appointed guardian ad litem on behalf of Ethan Crumbley.
Thank you. And Mr. Crumbley, could you state your full name for us, please?
Ethan Robert Crumbley.
Thank you, Mr. Crumbley. If at any time you cannot hear or understand myself or any of the parties to the proceeding, will you please let the court know?
Yes, ma'am.
And we are proceeding remotely instead of in person at the courthouse. Mr. Keese, is that with your consent?
It is, Judge. Thank you.
And Ms. Lofton.
Yes, Your Honor, I did discuss that with Mr. Crumbley. We are okay today to proceed by Zoom.
Thank you. So as the attorneys have already mentioned, Ms. McKelvey has been appointed by the court this past Friday. The request was made by the defense and was agreed to by the prosecution. And the court finds that it is in the defendant's best interest for that appointment. The guardian ad litem duties and authorities are set forth in a court order that is contained in the court's file. There was also a stipulated order for discovery, or protective order, I should say, that was entered into on Friday. I did just receive another copy with the original signature of yourself, Mr. Keist. It was attached to the front of the file when I walked in. Does that mean you want me to re-sign the order and redate it for today's date, or was that just for the court's file?
Judge, that's just for the court's file. Thank you.
Okay, great. Thank you. So, and I do want to thank all the attorneys for working together on this matter. I really appreciate it. That's evidenced by the protective order that I'm sure took some time to agree upon. So I appreciate your continued cooperation with one another in the court to make sure that the interests of justice are served. So thank you again. And I know that discovery is coming in and it's being provided to Ms. Lofton and Ms. Hopp. What's the status of that?
Thank you, Judge. We were able to get approximately 500 pages of reports and witness statements to counsel on Friday after the protective order was agreed to and submitted to this court. We do have a number of items outstanding. As this court can imagine, this was an extremely unique circumstance. There are a number of witness interviews to be commenced. For one reason in particular, Judge, is that a number of these children who were at the school were victimized and traumatized themselves. That naturally has caused some delay in those interviews commencing, Judge. Just this morning, the prosecutor's office did receive from the sheriff's office a flash drive with over 340 items. That includes in-car video, it includes recorded witness interviews, witness statements, all things that we will turn over to defense. But as this court indicated, discovery is ongoing and the reports are continuing to come in. So this is, by the nature of the case and the scope of the investigation, this is going to take a little bit of time, Judge.
Thank you. So with that, Ms. Lofton, I'm assuming you're requesting an adjourned probable cause conference there. Both parties are, I would assume.
That is correct, Your Honor. I want to make sure that we are able to view all of the discovery before we form decision about whether or not we will be holding the preliminary examination. So I am asking that already scheduled date be adjourned until after the new year.
Thank you. And if we do schedule it on January 7th at 9 in the morning, will that give you and Ms. Hopp enough time to properly make that decision?
I believe so. If for some reason there is an even longer delay in receiving the discovery, Mr. Keast and I can contact the court.
That sounds
Certainly.
good. Have you discussed with your client the waiver of the statutory time period?
Have, Your Honor. My client understands that he has a right to a preliminary examination within 21 days. Because of the extreme volume of discovery, my client is fine with having the exam set outside of that 21-day period so we can all be on the same page and so that he can review all of the discovery in this case.
Thank you. Mr. Crumbley, did you hear and understand what your attorney just stated?
Yes, ma'am.
And are you in agreement with that?
Yes.
So you're not waiving, of course, your right to a preliminary exam, just the right to have it heard within the statutory time period, and that is, of course, so your attorney can properly prepare for a preliminary exam if one is necessary. Again, do you understand and agree to that?
Yes, ma'am.
I do find good cause to waive that statutory time period. I will adjourn the probable cause conference to January 7th at 9 a.m. And I guess I would ask if this should be done remotely or not, just like today. Does that make sense under the circumstances?
Your Honor, at this point, we can set it for a remote hearing. If in between now and that date, Mr. Keast and I decide it would be better to be in person based on what will be actually taking place on that day, we can definitely advise the court.
Absolutely, because of course either of you can make that request, and if either the prosecution or defense would require that, then it will be in person. So we'll initially set it remote and we'll go from there.
That's fine. Thank you.
Thank you. Ms. McKelvey, do you have you had a chance to meet with Mr. Crumbley? Were there anything that you wanted to indicate?
Your Honor, I did have an opportunity to meet with him on Friday afternoon. At this point, we're able to interact, through the normal process on the screen. Your Honor, I don't know whether this is the appropriate time or you would prefer a motion. I do have concerns that his confinement at the Oakland County Jail and pursuant to MCL 764.27A, I'm not sure that he is fully away from the sounds of the adult inmates. And pursuant to the court rule, basically 6.909, there really has to be an assessment that he is either considered a menace to other juveniles or may not otherwise be safely detained in a juvenile facility. I understand the severity of what occurred. I think everybody does, including Mr. Crumbley, but I don't know that simply indicating that because the victims were of his age that he would necessarily be a menace. So I do have concerns for him and his mental and emotional well-being He currently is not able to benefit fully by what every other inmate at the jail can. Some has been due to a watch, but it is just very difficult. And the court knows the jail isn't conducive. It's not designed for juveniles. So, so I would just like some direction. Do you want a written motion and I can lay everything out? I just feel that if I have to look out for what is best interest, it's not being at the jail. I believe his needs can be met at the village. At least he will have greater human contact. He will have more services available to him to help him through this. I just feel that it is truly in his best interest, and I don't know that he really meets the standard of the court rule and the statute. And I know that, you know, his charge is not unique in the sense that there have been other children housed at the village with these type of offenses and being charged as an adult. I just feel that he's, you know, I'm not being humorous when I say this, but he could still at least be in school. I mean, there are things, he is still 15 years of age. And there are certain things, many things he's not going to get at the jail. And so I'm imploring you on behalf of him and what's in his best interest that we allow him to go back to the village. I'm not aware for the brief time that he was there he caused any difficulty. I just think for his age, his mental, physical, emotional well-being, housing him at the village would serve him more than where he currently is. I know from what he told me on Friday, he hears adults in the cells next door to him. Pursuant to the statute, he's not supposed to, and I'm of the belief that they are adults, that they are not other juveniles.
Thank you.
Your Honor, I can speak to that as well, and before Mr. Keast has an opportunity to respond, Your Honor.
Sure.
I watched the arraignment, and I understand that Mr. Keast made the argument at that time pursuant to MCR 6.909. And after reviewing that statute, Your Honor, I honestly do not believe that my client should be considered a menace to other juveniles. This is someone who has never been in trouble before. This is not someone who has a history of assaulting kids his age or any other negative contact with his peers. This one isolated incident is all that we're looking at here today. And also, I'd like to speak to the fact that there are other juveniles housed at Children's Village charged with murder. This would not be the first time. There's others there now. So I definitely believe that society is protected, as well as the other juveniles at Children's Village, if he was to be returned to Children's Village. And again, I also spoke with my client and agreed with Ms. McKelvey. He's being housed in the clinic. The clinic is still being used for adults that have medical ailments and medical issues. So there are adult inmates that are housed around him. And if you look at the specific language of the statute, I believe that we are violating that statute.
Thank you. Mr. Keast?
Thank you, Judge. Judge, this cannot be compared to any other case that this court or any court in this county has seen before. And calling this an isolated incident, quite frankly, does not do it justice. This was a mass murder at a school, Judge. This was planned. It was premeditated. The evidence that we have and that we discussed at the arraignment showed it was premeditated for a period of time before it was commenced. The defendant didn't just attack other individuals, he targeted juveniles. This defendant fits MCR 6.909 to the T. This court has already made a ruling that the presumption is great that the juvenile committed the offense, and the juvenile is charged with first-degree murder. This court already made the ruling that this court could move the defendant from Children's Village to the Oakland County Jail. I've spoken with Captain Thomas Bida of the Oakland County Jail. He's provided me with watch sheets. This defendant is monitored every 15 minutes. His food intake is monitored. His weight is monitored. He has access to mental health care should he choose. He has access to medical care should he choose. If counsel is prepared to put such facts on the record regarding the Oakland County Jail's inability to house this defendant, I would ask for a written motion, and I would also ask this court to review in camera the Oxford High School video that does in fact prove beyond any doubt that this defendant is the individual who perpetrated this offense on other children, Judge. Children's Village is not a secure facility. They have had escapes in the past, in the recent past, I can't imagine a situation where we could put this defendant in a school environment after what he did on November the 30th, Judge. So if we are going to readdress this ruling from this honorable court, I would ask it be by written motion. I would ask the opportunity for this court to review certain items in camera. Thank you.
Thank you. The court rule that is being addressed is MCR 6.909, which is the place of confinement for the juveniles, and allows the court for a juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. While I did make a ruling prior, I still feel strongly about that his conduct could be a menace to other juveniles. I think his placement is appropriate in the adult facility, specifically the Oakland County Jail. And he, of course, shall be confined and meet the statutory guidelines when a juvenile is in that facility. So the only thing I'm hearing right now that may potentially be a violation is that he can hear other inmates who are adults. Is that correct, Ms. McKelvey?
Yes, Your Honor, that's my understanding.
Okay. That means...
Judge, I will speak.
Go ahead.
I'm sorry. I did not mean to interrupt, Judge. I will speak personally with administration at the Oakland County Jail as soon as we end this call, and I will make sure that the defendant is neither within sight nor sound of any adult at the jail.
Thank you. Obviously, we need to be compliant with the statutes, and if that is it is obviously a concern, and thank you for addressing that. Anything further?
No, Judge, I will speak with counsel, and we'll make sure that discovery gets to counsel as soon as it is available.
Thank you.
Nothing further from the defense, Your Honor.
Thank you. You may all disconnect. We'll see you back on the 7th.
Thank you, Your Honor.
Thank you, Judge.
We let other people in on other cases, on all the other PCCs.
Thank you, Your Honor.
Thank you. Why don't we take a 5-minute recess before we start, because so they don't feel like they're disrupting anything. If you want to break down, that's okay. We've got other cases to be heard.
Appreciate it. Thank you.
Thank you, Anna. Sure.
So what do you guys think? Do you think he should be allowed to go into a juvenile facility, or do you think he should have to stay at the regular facility? I mean, because regardless, though, after the trial and he gets charged or convicted, if he does, which I'm sure he will, and he probably gets life, right? You know, he could stay, I guess he could stay in the juvenile until he's of age, and then he'd be transferred to the regular prison when he's old enough. I mean, why couldn't they just do that? Because eventually he's going to be in that prison, but just until he's... Yeah, I guess then what makes the difference, really, then, if you think about it? I mean, eventually he's going to be there anyway, but I guess, you know, while he's younger, he could be in the juvenile, but then if he's going to be there anyway in a few years, what's the big deal if he's there a few years early? I mean, he's going to probably be spending his life in there, so who cares what he's like exposed to, because eventually he's going to be exposed to it all, right? I don't know. I'm just thinking out loud here. Let me know what you guys think. All right. Have a good night.
Really, 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 really need your love. I'm begging you to be kind. I'm begging